I want to start by telling you what this case is not about. And Jim's litany of examples at the end of his presentation to me characterizes the distortion that I think CLS has brought before the court. And it does that by claiming they're being forced to admit people who disagree with their views. No one is being forced to do anything here. CLS's brief, many of its amicus briefs in support of CLS use the words like forced, required, compelled. Mr. Bopp's brief has one of those words 60 times.
Only?
Only. Really, this is like me telling my kids, you get your allowance if you do your chores. That's a real choice. And I'll tell you, my daughter wants her allowance and my son doesn't. His room's a mess, hers is pristine. It's also not about whether CLS survives or perishes. We're talking about a few $100s a year. We're talking about access to bulletin boards, advertising in a weekly official newsletter, posting things on a bulletin board. They can still access email, they can still access Facebook, and demonstrating that it's not about whether it survives or perishes is the fact that after CLS chose to forego recognition, it continued to meet, it continued to hold meetings, and its membership nearly doubled. Likewise, it can survive with the funding. It can survive accepting people who don't agree with its underlying mission. And the predecessor organization to CLS did that. For about a decade, it survived. It continued to advance its message despite living with the policy that Hastings wants to keep in place. It's also not about equal access. CLS wants a special exemption from a policy that applies to everyone else. So what is the case about? I think it's about the government's ability to allocate its funds as it wants to. And now, it's well established that the government, for example, need not fund private schools if it funds public ones. It doesn't need to subsidize abortions if it otherwise covers medical care for the poor. Now, is speech different? Can the government pick and choose among speakers that it chooses to subsidize? Again, the answer is yes. The government can choose to fund the advocacy of options other than abortion, but not to fund the advocacy or even information being provided to women about the availability of abortion. It can deny tax exemptions for all groups to lobby, but it can allow veterans groups to get that kind of a tax exemption. It can fund a whole host of artistic projects, the NEA can, but it can decline to fund Karen Finley to smear her breasts with chocolate. So are there any limitations on the government picking and choosing among speakers? Here the answer is yes. When purely private speech is involved, the government cannot discriminate on the basis of viewpoint. And that's clear from a case called Rosenberger, is probably most illustrative of that principle, that the government there, UVA, couldn't fund a whole range of student groups at a university, but then refused to fund a group that advocated a religious perspective. So the question then boils down to, in this case, is this viewpoint discrimination or not? And that's really the main point of contention between the parties here. I don't think this policy, the anti-discrimination policy, is viewpoint discriminatory. I don't even think it's content-based. And if it's not content discriminatory, then it's plainly not viewpoint discriminatory. The test for whether a restriction is content neutral is whether it's, I'm quoting here from a Supreme Court case, justified without reference to the content of the regulated speech. Here, the non-discrimination rule applies to all groups, regardless of their perspective. They might be racist or anti-racist. They might be anti-gay rights. They might be pro-gay rights. They might be religious. They might be atheist. At most, the regulation has a disparate impact, meaning it affects some groups more dramatically than other groups. But the court, again, has said that an incidental effect on some speakers or messages, but not others, doesn't render a policy content discriminatory.